Three separate events occurred at the Supreme Court of the United States over the last 2 years that directly impact every firearm owner in the nation. None of these developments reached the front page of most local newspapers. None of them stayed in mainstream evening broadcasts for long, and none of them maintained traction on social platforms beyond a short cycle before being replaced by newer headlines. Yet all three were decided, all three are binding, and all three currently stand as operative law. What concerns me as an attorney who has spent 2 decades observing how legal information fails to reach the people most affected is this disconnect between what has changed and what people actually know. I have met firearm owners who can recall detailed statistics about their favorite sports team's quarterbacks from last season. I have spoken with others who can precisely describe the specifications of a weapon purchased years ago purely from memory. Many are engaged, attentive, and deeply serious about their Second Amendment protections. However, when asked about these 3 Supreme Court decisions, rulings that affect where individuals may carry, who is legally permitted to carry, and which federal restrictions on firearm accessories have been removed, the response is often the same: uncertainty or complete lack of awareness. This matters because firearm law does not operate like most areas of regulation. Ordinary statutes primarily define prohibitions. These Supreme Court rulings instead define permissions. They clarify what individuals are now legally allowed to do, what rights are currently recognized, and what constraints no longer apply. A person unaware of these changes may unknowingly avoid locations where carrying is now lawful. Another may continue believing a restriction exists even after it has been struck down at the federal level. Lack of awareness does not only risk violating rules, it can also mean failing to exercise rights that now exist. The phrase, ignorance of the law, is commonly understood as failure to know restrictions. Less discussed is the parallel consequence of not knowing when legal barriers have been removed. That gap can be just as impactful. The 3 rulings at issue are United States versus Hermani, Garland versus Cargill, and Ward versus Lopez. Ward versus Lopez, decided on June 25, 2026, invalidated a Hawaii statute requiring firearm carriers to obtain explicit approval from property owners before entering private property open to the public while armed. During oral arguments, members of the court described the statute as resembling a vampire rule, referencing the idea that entry required prior invitation. United States versus Hermani, decided 9-0 on June 18, 2026, struck down the categorical federal ban preventing firearm possession by regular users of marijuana. Garland versus Cargill, decided in June 2024, invalidated the ATF's bump stock prohibition, concluding that the agency exceeded its statutory authority when it attempted to classify bump stocks as machine guns through regulation. Together, these 3 decisions represent significant changes in federal firearm law, 2 of them occurring within the last 2 weeks of this recording period, and 1 still widely misunderstood despite being issued 2 years earlier. Under this decision, individuals holding concealed carry permits are allowed to enter private property that is open to the public, including businesses, restaurants, and retail locations, without needing explicit approval from the property owner in advance. The property owner still maintains authority over their premises, and may forbid firearms by posting clear signage or by requesting that a permit holder leave the location. However, the legal baseline changes. Instead of requiring permission as the starting point, the rule assumes carry is allowed unless it is specifically restricted. This is not limited to Hawaii as a standalone issue. Multiple states, including New York, New Jersey, California, and Illinois, have adopted legal structures that function on an opt-in model for carrying firearms on private property. These frameworks were designed to reduce the practical scope of concealed carry permits even after the decision. In Bruin, eliminated may-issue licensing systems. The ruling in Ward versus Lopez places these opt-in systems under constitutional scrutiny. Its reasoning raises direct questions about whether similar laws in other states remain valid under the same legal standard applied to Hawaii. For individuals who currently hold carry permits in states that use opt-in or permission-based private property rules, including New York with its post-Bruin Concealed Carry Improvement Act provisions, this decision is directly relevant. The appropriate step is to seek guidance from a qualified firearms attorney within that state to evaluate how the Ward versus Lopez ruling interacts with existing local statutes. It is not safe to assume that because Hawaii's statute was struck down, every similar law elsewhere is automatically invalid. Each state's legal code contains specific language that must be analyzed individually, and federal appellate courts may interpret the ruling differently depending on jurisdiction. What is clear is that Ward versus Lopez now serves as the primary precedent in evaluating these frameworks, and its reasoning extends beyond a single state. One major misunderstanding in media coverage is the tendency to treat this as a Hawaii-only ruling. In reality, the decision addresses the broader constitutional question of whether opt-in private property carry systems are permissible at all. Several states enacted such laws after Bruin, and the ruling now places their legal durability in question. The issue is not localized, it is national in scope. The second major decision, United States versus Hermani, also decided by the Supreme Court on June 18, 2026, was issued as a 9-0 ruling. The court held that it is unconstitutional for the federal government to categorically prohibit firearm possession solely on the basis that an individual is a regular user of marijuana. Justice Gorsuch authored the opinion in this case. It upheld a lower court ruling that dismissed a federal charge brought under 18 U.S.C. 922G3 against Ali Jimeni, a Texas resident who acknowledged regular marijuana use when questioned by authorities. The government attempted to justify the restriction by comparing habitual drug users to historical laws that disarmed habitual intoxicated individuals. Under the Bruin framework, the government must demonstrate a historical analog from the founding era to support modern firearm restrictions. The court rejected that comparison. The historical category of disarming habitual drunkards was not considered sufficiently precise to justify a broad and automatic prohibition on firearm possession for modern substance users. A key aspect of this ruling that has not been fully reflected in much of the reporting is its scope beyond marijuana itself. While marijuana use was central to the case facts, the statute at issue, 922G3, applies broadly to any unlawful user of or individual addicted to controlled substances. The court's reasoning, particularly its rejection of the habitual drunkard analogy as a valid foundation for categorical disarmament, affects the entire structure of how that statute has been applied. Although the case arose from marijuana use, the constitutional analysis is not limited to that substance alone. This creates a stronger basis for future challenges involving other controlled substances under the same statute. The government's central historical justification has now been rejected unanimously. That argument would likely be required again in any similar case, regardless of substance type, and it has already been found insufficient. According to analysis from the Congressional Research Service, the court may choose to accept additional cases involving 922G3, vacate lower court rulings, and send them back to appellate courts for reconsideration in light of Hermani. In practical terms, this means the categorical enforcement of 922G3 has been constitutionally weakened. The exact limits of the statute will now be defined through ongoing litigation rather than assumed settled precedent. The ruling is binding, unanimous, and immediately relevant to millions of individuals who were previously treated under a fully categorical interpretation of that law. A frequent misrepresentation in coverage is the framing of Hermani as a narrow marijuana-specific decision. The legal reasoning extends further. The court's rejection of the historical analogy undermines the broader theoretical basis of categorical firearm prohibitions tied to substance use, and future cases will determine how far that reasoning reaches. The third major ruling, Garland v. Cargill, decided in June 2024, addresses firearm accessories and the limits of federal regulatory authority. Although this decision is now 2 years old, its effects continue to shape legal interpretation and enforcement across the country. In this case, the Supreme Court ruled that the Bureau of Alcohol, Tobacco, Firearms, and Explosives exceeded its statutory authority when it classified bump stocks as machine guns and enforced a ban on their possession. Following the 2018 mass shooting in Las Vegas, where a shooter used rifles equipped with bump stocks, the ATF issued a regulatory rule stating that bump stocks fell within the definition of machine guns under the National Firearms Act. Because machine guns manufactured after 1986 are prohibited for civilian ownership, this classification effectively created a nationwide ban on bump stocks. The Supreme Court in Garland v. Cargill determined that this classification was incorrect. The court held that bump stocks do not transform a semi-automatic rifle into a machine gun under the statutory definition provided by the National Firearms Act. As a result, the ATF's rule was invalidated for exceeding the authority granted by Congress. The regulation was struck down, removing its legal effect at the federal level and restoring the status of bump stocks outside the scope of that administrative ban. Do you like this personality? This is the critical detail that most reporting does not clearly explain. At the federal level, there is no active Bureau of Alcohol, Tobacco, Firearms, and Explosives rule banning bump stocks. The federal restriction that was in force from the year 2018 through 2024 is no longer in effect. Possessing a bump stock does not, by itself, violate any current federal regulation. However, this does not mean unrestricted legality, and this is where misunderstanding becomes dangerous. A number of states have enacted their own independent statutes that prohibit bump stocks. States including California, New York, New Jersey, Colorado, Massachusetts, and others maintain their own bans. In those jurisdictions, possession of a bump stock remains unlawful under state law, regardless of the federal Supreme Court decision. The ruling in Garland v. Cargill removed the federal regulation, but it did not override or invalidate state legislation. State-level restrictions remain fully enforceable. If a state has its own prohibition, that law continues to apply even after the federal rule was struck down. The practical implication is straightforward. Anyone considering possession or purchase of a bump stock must verify state law directly through official statutes, rather than relying on general commentary or online summaries. The Supreme Court decision does not create universal permission across all states. It only eliminated the federal administrative ban issued by the ATF. A common error in public discussion is the claim that bump stocks are now universally legal. That is incorrect. They are no longer prohibited under federal regulation, but legality depends entirely on state-specific statutes. Several states continue to enforce their own bans, and those laws remain valid and enforceable. Turning to the broader legal context, these three Supreme Court rulings reflect a consistent application of the Bruin framework established in 2022. That framework requires firearm regulations to align with historical tradition of gun control in the United States. Ward v. Lopez applied this standard to private property carry restrictions. United States v. Hermani applied it to categorical firearm possession prohibitions tied to substance use. Garland v. Cargill applied it to federal regulatory authority over firearm accessory classification. In each case, the challenged rule or statute failed under that historical analysis. Hawaii's opt-in private property carry system lacked a sufficient historical analog. The categorical disarmament of marijuana users under the habitual drunkard justification was rejected unanimously. The ATF's classification of bump stocks exceeded the authority granted by Congress under the National Firearms Act. Across these decisions, three separate areas of firearm law were directly affected: carry permissions, prohibited person categories, and accessory regulation. Each one was evaluated under the same constitutional test, and each one was struck down or limited accordingly. According to legal analysis, including reporting from Scott's blog, the Bruin framework has triggered thousands of legal challenges nationwide as courts reassess firearm restrictions under the text, history, and tradition standard. These three rulings represent active outcomes within that ongoing process, not isolated endpoints. Additional legal disputes are already moving through the courts, including cases involving assault weapon bans, magazine capacity limits, and age-based firearm purchase restrictions. All of these are being measured against the same constitutional framework established by the Supreme Court. To summarize the current state of the three rulings, Ward v. Lopez, decided June 25, 2026, struck down Hawaii's opt-in private property carry requirement. Carry permit holders may enter businesses open to the public without prior affirmative permission, though property owners may still prohibit firearms through signage or removal requests. Similar laws in other states may now face constitutional challenges. United States v. Hermani, decided June 18, 2026, by a 9-0 vote, struck down the categorical federal prohibition on firearm possession for regular marijuana users under 18 U.S.C. 922 G3. The court rejected the habitual drunkard analogy as a valid historical basis. The broader application of this reasoning is still being determined through ongoing litigation. State laws and impaired carrying restrictions remain unaffected. Garland v. Cargill, decided in June 2024, invalidated the ATF's bump stock ban as exceeding statutory authority under federal law. Bump stocks are no longer prohibited at the federal level. However, multiple states maintain independent bans that remain fully enforceable and are not affected by the Supreme Court ruling. Taken together, these three decisions illustrate a significant shift in how firearm law is being interpreted and applied in the United States. They have not received widespread mainstream attention, but they directly influence how existing rights are defined and exercised. A firearm owner who is unaware of Ward v. Lopez may still be avoiding locations where carry is now legally permitted. A firearm owner unaware of Hermani may still believe a categorical federal restriction applies where it has been struck down. A firearm owner unaware of Cargill may incorrectly assume a federal ban still exists when it does not. In each case, knowledge of the ruling determines whether a right is actively exercised or unintentionally restricted. The gap between what the Supreme Court has decided and what the public understands remains significant. Closing that gap is essential to understanding the current legal landscape surrounding the Second Amendment and how it continues to evolve. Stay informed on the next wave of Supreme Court cases that may reshape firearm laws again, including pending challenges on assault weapons, magazine limits, and age-based restrictions as the legal landscape continues to develop.